Good morning.
Good morning, Your Honor. May it please the court, Brian Gowdy of Creed & Gowdy on behalf of Stuart Weber, the appellant and the proposed class representative. The question presented is this: does a putative class representative have standing to prosecute the class's claims if, after the filing of the class complaint, but before the class certification decision, the defendant unilaterally offers him full relief on his individual claims?
That's a good question, but Mr. Gowdy, do you want to reserve any time?
5 minutes. Thank you.
All right, you got it. Go ahead, sir.
The correct answer is yes, if the representative has diligently sought to represent the class. But however this court answers this question, it will conflict with other DCAs and courts. If it answers no, as USAA urges, it will conflict with the 4th DCA's decisions in Jackson and Kaner, as well as with the majority of federal courts and other state courts. If it answers yes, as we argue, the court will conflict with the 1st DCA's Ahern decision and the 3rd DCA's Senate decision and some federal and state courts. Before diving into those conflicts, I think it's important to point out where the law is settled, and I don't believe the parties disagree. And I would point the court to sections 2:11 and 2:15 of the Newburgh Treatise that has a wealth of authorities for these, I think, largely unsettled propositions. The first is that the class representative must have a live claim when the class complaint is first filed. That would be note 6 and 2:11 of that treatise. In fact, 2 of the primary cases on which USAA relies, Graham from the 5th DCA and Chinchilla from the 3rd DCA, involve circumstances where the proposed class representative had been given full relief by the defendant before he or she filed the class complaint. And thus, we agree in those cases, a proposed plaintiff would lack standing, and so do all courts. This case is different because Mr. Weber indisputably had been injured.
Mr. Gowdy?
Yes, ma'am.
If we do indeed consider that it just has to be simply that the plaintiff has a live claim upon the filing of the lawsuit, doesn't that run afoul of SOSA, which says that the case or controversy will continue through the existence of the litigation?
No, it doesn't. And here's what was stated in SOSA, which you will find also stated in some form in every one of the federal cases that I've cited starting at pages 21 to 24 of the brief. What it says there is to satisfy the standing requirement for a class action claim, the class representative must illustrate that a case or controversy exists between him or her and the defendant, and that this case or controversy will continue throughout the existence of the litigation. That principle is a general principle, but like so many other areas of the law, the standing doctrine can't be summed up in a single sentence or a single formula. And what the federal courts have recognized, including in the Weiss decision that was cited twice by the 4th DCA, is that that doctrine is subject to 2 principles. One is relation back, and the other is the capable of repetition yet evading review. And if you were to go to the SOSNA case from the US Supreme Court, which then Justice Rehnquist wrote, you would see a sentence almost identical to what you read in the Florida Supreme Court opinion in SOSA. And what it says there is there must be a named plaintiff who has such a case or controversy at the time the complaint is filed and at the time the class action is certified by the district court. But then there's a footnote there that then Justice Rehnquist put that all the federal circuit courts we cited in our brief have picked up on. And the footnote's not in SOSA because it didn't apply there because we didn't have a picking off. And SOSA, the Florida Supreme Court case, I'm being clear, the 2 are almost the same name. But and so the SOSA case, Judge Smith, doesn't address picking off a class representative. It says nothing about it. But these other cases all have cited to this footnote from SOSNA, and these aren't just class certification standing doctrines. They're doctrines that apply across the spectrum of class certifications decisions. And they, again, are relation back and capable of repetition, yet evading review. And what then Justice Rehnquist said was, there may be cases in which the controversy involving the named plaintiffs is such that it becomes moot as to them before the district court can reasonably be expected to rule on a certification motion. In such instances, whether the certification can be said to relate back to the filing of the complaint may depend upon the circumstances of the particular case, and especially the reality of the claim that otherwise the issue would evade review. And all the federal courts that we talk about, that again, the fourth DCA cited the seminal case, which is Weiss from the Third Circuit, they discuss both of these principles and say, here, when you have a class action, especially when there's a small amount of controversy here, $115, $116, they are acutely susceptible to becoming moot. And therefore, the courts have recognized in that instance, we're going to look at the moment of certification, but we're going to relate back to the time of the filing of the complaint. Because if we don't do that, and what would happen is that a defendant for these small claims will pay the $120 for one person and not pay the $120 due to 10,000 other people.
But aren't we butting up against the ability of the parties to freely negotiate settlements before class certification? Because the third district is pretty clear about it. An insurer can try to correct errors prior to class certification. It cannot pick off a class rep after certification. That's De La Rosa. Terrence says, in the absence of an order prohibiting common class action, defendant is allowed to deal with members of a potential class in ordinary course of business. Even the 11th Circuit seemed to carve out in Stein, that was an unaccepted offer of judgment. In this particular case, we've got something very, very different. USAA says, we're paying you, we gave you a check, and we're conceding to a confession of judgment, and you get your fees. That's different than an unaccepted OJ. Tell me about that.
I have a few responses to that. I don't think it's all that different because we never accepted the tender. So the only difference is between here and Stein is they tendered the check. And in Stein, I don't think there was an attorney fee provision at issue. So here there is, and they added that in. So
this is a confession of judgment.
Well, that's my first point. I don't think it's, Your Honor, but we didn't accept it. The premise of your question at the beginning was, are you interfering with the parties to freely negotiate? Well, Mr. Weber didn't negotiate this. Mr. Weber didn't agree to this. There were no negotiations. This was, as you just said, a confession of judgment. And so to answer your first question, absolutely not. USAA is free to negotiate with any unnamed class member. If they fail to pay for the windshield of 1,000 or 500 or 100 or whoever, we don't know because there was no discovery was never provided. They are free to go and negotiate with those individuals and get a resolution. And if they can resolve with all the class members, then we're not going to have a class because what their lawyer has said without any proof, just an assertion of counsel, without any evidence, is that this is a one-off. So if that's true and if they had produced the evidence, we wouldn't be able to certify a class. But to answer your question, no, nothing precludes them from negotiating with Mr. Weber or from the class members. But what they don't want to do that, Your Honor, what they want to do is they want to force Mr. Weber to accept for his individual claim and then prevent the class action from going forward. So that's really what's going on here. And the reason the courts have had these relation back and capable of repetition yet evading review doctrines is that in this instance, a class would never be practically certified, no matter how many people may be injured by this practice. You know, some
But
class,
Mr. Gowdy,
yes.
that the fact that Mr. Weber's claim has been satisfied and with the confession of judgment it's not precluding, when you say it's precluding the class, it doesn't mean that another rep down the road may bring an action. But I think your point is that every time there's someone files, then they're going to pick off the class and a class will never be certified. I think that's your point. But I guess
sorry, I didn't mean to interrupt. Go ahead, Your Honor.
I guess I just see this differently than Kaner and Jackson, where there was offers, and whereas here we have an actual confession of judgment. I mean, do you disagree that it's a confession of judgment here?
No, I don't disagree, but
Okay.
I don't think there's any difference, because what you're talking about is the mooting. That difference that you're talking about, which is talked about by the Supreme Court in the Campbell-Uwald case, 2016, I think, that would affect whether or not the individual claim might be mooted, but it may or may not. That's sort of an undecided question out there. But we're going to accept and assume that Mr. Weber's individual claim is mooted. But what's not mooted, as you just said a moment ago, you're absolutely right. The claims of the unnamed class members are not mooted, but what they are is they're unrepresented. And so I think you're making artificial distinctions. If you see some difference between a tender of the check and an unaccepted offer, they're both, one way that we have contracts, right, is by performance. So I don't understand why sending the check is any different than sending a letter saying I'm going to pay it.
Well, because one's the equivalent of it. The difference is one's the equivalent of a judgment, whereas one's just an offer and it's dealt with differently, and it makes whatever live claim they may have had, it makes it moot and resolved.
Right.
I mean, isn't that the distinction?
I understand that distinction, but when we're
And
talking,
it's a key distinction, though.
I think it's more of a key distinction there's always two questions in these cases, Judge Smith. The first is whether the individual class representative's claim is moot. The distinction you're making matters for that, but it doesn't matter when you come to the class's claims. And so the dilemma that the courts have had is when you have, whether it's a case like this that's susceptible to being made moot, or it's inherently transitory. Those are the two categories the Stein case lays out. Is that you're always going to have a problem where maybe the representative gets lost. The Sosna case from the U.S. Supreme Court, the problem they faced there was the representative was challenging a 1-year durational requirement in the Iowa divorce statute. Well, litigation takes more than a year, and you would continually be losing your class representative. Here, you would be continually losing your class representative, not because of a time period, but because it's obvious advantageous to the defendant. If you have 10,000 or 1,000 or 1 million class members, why not just pay one and then pay the next one and pay the next one? And so the courts have recognized that. I see I have about a minute left until I got to go to rebuttal. If you have any more questions, I'll answer them. If not, I think I'll just reserve, if I may, Judge Sleep, the rest of my time for
Yes, sir.
rebuttal.
You'll have your 5 minutes.
Thank
Ms.
you.
Aldrich, you're on mute. Thank you.
Can you hear me?
Yes, ma'am. If I had $1 for every time I said that, we could build our own courthouse. Thank you.
May it please the court, I'm Marcy Aldrich, and I'm here on behalf of the USAA General Indemnity Company. Weber lacks standing to pursue the class action in this case because, as conceded, USAA confessed judgment on Weber's individual claim. After the suit was filed, USAA confessed judgment, paid Weber's claim in full, which is undisputed, and acknowledged his entitlement to attorney's fees and costs. USAA took this action before the court even started considering the issue of class certification, 3 months before the motion for class certification was filed. Weber admits that the claim was paid in full. The issue is therefore whether Weber has standing to continue to represent a class of similarly situated insureds when his own claim is unquestionably moot. Under Florida law, as the trial court found, the answer to that question is no. Weber bears the burden in this case of establishing his standing by showing that he has a sufficient interest at stake, and also that the controversy between him and USAA will continue throughout the lawsuit. Weber cannot meet the burden. Nonetheless, and despite the clear Florida law, Weber argues that USAA did not moot his claim by paying it, even though that occurred again well before class certification proceedings had begun. To make the argument, he relies on he relies on 2 Fort DCA cases, a federal case, and a bunch of other federal and other state cases. The 2 Florida cases on which he primarily relies, which are the Jackson and Connor cases from the Fort DCA, are easily and factually distinguishable. They either involve unaccepted offers of judgment, not confessions of judgment, as has been acknowledged here, or they involve incomplete payments of the amount at issue, as is what happened in Connor. That is also true for most of the federal and other state cases on which Weber relies. They are factually distinguishable. Most of the federal cases, including the 11th Circuit Stein case and the Supreme Court Campbell-Ewald case, involve unaccepted offers of judgment. That is appreciably different than the unconditional confession, payment, and acknowledgement of entitlement to attorney's fees and costs that is issue in this case. Some of his cases, the Supreme Court Roper case, for example, involve payments that were made after class certification, and USAA would not dispute that a payment made post-certification would not have divested Weber of standing to continue the class action cases. He's left with a handful of other state cases or federal cases. And as Weber's counsel acknowledged, those are based on some policy considerations about the other class members potentially being left without an economically viable recourse or remedy if the court finds that the named plaintiff's claim has been mooted. But this is where there is a significant and material distinction between Florida and Florida law and these other cases. This is an insurance case in Florida. Unlike, for example, the Frazier versus Castle Ford case, which is a Maryland case on which Weber relies. In that case, it involved a class of warranty purchasers. And those purchasers were considered by the court to be, quote, people for whom recourse to a legal remedy would not be economically feasible. But Florida has eliminated that economic infeasibility question with regard to insurance claims. The attorney fee shifting statute, Florida statute 627.428, unquestionably provides Mr. Weber or any member of this class with an economically feasible remedy. Because here in Florida, if you sue an insurance company and you prevail for basically any amount, $300 or frequently amounts even less than that, you will not only recover the amount, but attorney's fees and costs. And there are no shortage of attorneys that are willing to handle those cases, as any cursory review of the recent Florida Law Weekly supplement, which shows dozens, if not hundreds, of individual PIP or glass loss auto cases where counsel has been obtained and recoveries and attorney's fees have occurred. As this court said in First Floridian versus Myrick, by the enactment of 627.428, the legislature leveled the playing field in insurance claims. So the policy considerations that underlie the handful of cases on which Weber relies primarily, which again are either federal or other state court cases that are not controlling here. They rely on policy considerations that simply do not apply to the circumstances before this court in this case, where these insureds unquestionably have an economically viable recourse to address their claims, even on an individual basis. Weber also ignores Florida's public policy in favor of the pretrial resolution of insurance claims. Under Florida law, as set forth in the Turan, Ramon, and Chichilin cases from the 3rd District Court of Appeals, USAA acted properly by admitting its payment error and correcting it. Contrary to Weber's concerns here, that finding that Weber's claim has been mooted by the confession of judgment is not a death knell for Florida class actions, quite the opposite. First of all, the ability to correct a payment error before certification and having that essentially moot the named plaintiff's claim is not an issue of first impression. There are many cases cited in both, including the 5th, 3rd, 5th, 1st DCAs have addressed this. So this idea that you could correct your mistake and moot the plaintiff's claim is not an issue of first impression. It has been the law, and yet there is no shortage of class action cases in Florida. Moreover, if this truly was a systemic and ongoing practice of USAA's, which obviously USAA disputes, and USAA has admitted in its first motion to dismiss filed in this case with regard to the claim for declaratory relief, USAA admitted, we messed up. Our policy says we're not supposed to apply the deductible to the windshield repair, and the statute says we're not supposed to apply the deductible to the windshield repair. But if you have a case where there is truly a systemic ongoing problem, paying the nominal class plaintiff is not any sort of long-term protection. First of all, that payment is not without strings. Particularly, as I said, in insurance cases, once that's paid, the plaintiff is entitled to attorney's fees and costs, which again may be significant. Moreover, it doesn't stop the possibility of a second or third plaintiff trying to mount on a second class action. And it doesn't prevent, most importantly, the potential of hundreds or thousands, if there's truly a systemic practice, of individual lawsuits being mounted in county court, which arguably would be more expensive than one class action.
So Ms. Aldridge,
because again, every single one of those.
Ms.
Yes, Your
Aldridge,
Honor.
one question, sorry to interrupt you. Assuming we were to affirm, you do not see a conflict with the 4th. Is that true?
No, Your Honor, because as I said, the 2 cases that Weber cited from the 4th, the Connor and Jackson cases, they are easily and factually distinguishable. Jackson was an unaccepted offer of judgment, not a confession of judgment, not an unconditional offer with an acknowledgement of entitlement to fees. And Connor was, again, an offer, but also an incomplete payment where the treble damages that were sought by the plaintiff were not paid. So factually, Your Honor, we would not.
Well, let me ask you about the proposal for settlement 1.442. The legislature's carved out an extension to accept for a class rep or a class member to accept a proposal for settlement to 30 days after the date the certification is granted or denied. So the legislature carved out that extension on an OJ or PFS. Does that help or hurt your argument?
I think candidly it's of no effect on the argument because again, we didn't make a proposal for settlement here. If we had made a proposal for settlement and it was conditional as a proposal for settlement is, then that offer based on the rule would remain open till 30 days post certification. But again, that's essentially a settlement offer. It's a sum certain. It requires the agreement of the other side. It is not a confession of judgment, which is unconditional and subjects the defendant to, an undetermined to be set by the court unless the parties can agree amount of attorney's fees. So factually, the idea is that was a settlement offer and probably the policy reasoning behind keeping that open is appreciably different than a confession, where essentially we get back to Turan and Chinchilla, and the Florida courts have said, if you mess up and you attend to it and pay it and confess judgment and you do it unconditionally, then the nominal plaintiff is divested of standing and we don't proceed with the class action. So, I mean, I think the serious difference here with Jackson, with the proposal for settlement offer of judgment rules, is that this was not a settlement offer. It wasn't a proposal for settlement. It was an unconditional confession, as Weber has acknowledged. Your Honor, also to the extent, again, that Weber is worried that this is somehow a death knell for Florida class actions. As I said, there's not, if there's truly a systemic problem, this is not a good fix for a defendant, which is probably why it doesn't go on all the time when there are truly systemic problems. Because again, it doesn't stop a second class action, a third, or which could alternatively be worse, hundreds or thousands of individual lawsuits over the amounts. Moreover, Your Honor, Weber's argument essentially would require that as long as the plaintiff adds some class allegations to literally and potentially any complaint, that the court has to go through the class action hoops before it can resolve anything. And that gives a plaintiff a lot of leverage to address a claim which can otherwise be addressed. And the Ramon versus Aries case from the third DCA acknowledged this when they looked at exactly this question, where an insurer had corrected a payment error after the suit was filed, but before class certification. And in that case, the court recognized that class actions can create the opportunity for a kind of legalized blackmail against the defendant, because the class action comes with obviously additional costs. It comes with some institutional discovery, like some of the institutional discovery served here. So here we're in an interesting situation, unlike the cases on which Weber relies. We are not in a situation where Weber or any member of this class has no reasonable economic recourse to pursue their own claim. So the federal cases, the other state cases, the policy reasons underlying the handful of cases that support his theory, which are non-Florida cases, simply don't apply given the scenario that we are in with this insurance claim. But also, you have to consider that also, the converse of that is now all that a plaintiff would have to do is add some class allegations, and the insurer would not be able to confess judgment on a small claim and correct its error and fix the problem, particularly in a scenario like, as I said here, where we concede that the policy is clear, the statute's clear. With regard to this particular claim, there was a mistake and it got fixed. Accordingly, if the panel has no additional questions, we would ask that you affirm the trial court summary judgment.
Thank you, Ms. Aldridge. Mr. Gowdy, you're off mute. Good job. Go ahead.
Thank you, Your Honor. This is not about an insurance case. The Ahern case was not an insurance case. This is about Rule 1.220 and Florida's doctrine of standing. And Rule 1.220 was based on Rule 23. And as we cite, there's many cases saying that Florida courts follow federal decisions in construing it. And we've not just shown one case, we've shown 5 separate circuit courts of appeal that all agree with us on this, including
I have
the
a question about Stein. If I could ask you a question about Stein, because
Yes, sir.
the judge, posited what didn't happen in that case. And it said, if a defendant wishes to offer complete relief, he need not invoke Rule 68. The defendant can simply offer complete relief, including the entry of judgment.
Right.
That seems to be what we did here, or what USA did here.
There's 2 holdings in Stein, and the panel addressed what you're talking about is the first part of the case. The second part of the case, the 11th Circuit panel said we're going to assume that this offer of judgment mooted the individual claimant's claim, and we're going to say even if that's true, that he can still represent the class. And Stein rose in Tampa, the same place this case rose. So if you're in federal court, you have a different result right now than you do in state court. I think at the very least, that's something the Florida Supreme Court should address, that we're going to have completely different results, because the alternative holding in Stein will mean a different result across the street in Tampa. I also want to point out, Judge Sleet, and to the panel, that the reason this is important is that the moment the class complaint is filed, you have a fiduciary relationship to the class. We cite the Metzel case about this. You all may know of a lawyer named Henry Adorno who received a 3-year suspension because he did not appreciate that. He accepted a settlement offer on behalf of his individual clients and did not represent the class. And that's your question, Judge Sleet, about Rule 1.442 recognizes that. So Mr. Weber, he cannot just accept, and whether it's—
But Mr. Gowdy,
Yeah.
Mr. Gowdy, that's a completely different situation than we have here, though, because as you aptly pointed out, Mr. Weber didn't, accept the confession of judgment, and it was out of his hands. So that's really not the same situation that we have here, though.
Well, he didn't breach his fiduciary duty. He could have just taken the money and not done this appeal. And then I would suggest he is breaching his fiduciary duty.
Right, but he's
And-
not by the confession of judgment, I wouldn't say.
Right. Well, and I wanted to bring up the confession of judgment, if I may, Judge Smith, because the Fulton Dental case from the Seventh Circuit involves a tender. And the courts, the federal courts aren't seeing this distinction that the panel seems to be seeing when you're talking about picking off a class. There was a deposit of a payment into the court registry in the Fulton Dental case, 2017. That's the latest federal circuit court case. I would also point out in the Kaner case, there will be a conflict, Judge Sleet. The motion there was for an entry of a consent judgment. I'm not sure how you draw any distinction to a party seeking an entry of a consent judgment and a confession of judgment. Now, I will grant you, as USA has pointed out, the court in Kaner said, well, there wasn't full relief offered because the plaintiff there could have gotten trouble damages. However, the conflict you're going to have is in this last paragraph of the opinion, where the Fourth District, because it would have been very easy, obviously, for the defendant on remand to just say, oh, rather than pay you $1, we'll pay you $3 this time. All right. And the Fourth District anticipated that and gave specific directions to the trial court that on remand, before entering another final judgment, the court shall also consider and rule on Kaner's motion to certify the class, making it very clear that you couldn't just pick off the class plaintiff by tendering money or asking for another consent judgment. They use the word judgment, not just an unaccepted offer. So you will be in conflict. And I think, this case deserves the Supreme Court of Florida's attention, whether you do it through a certified question or conflict. I see that I'm out of time.
Yeah.
But would happy to answer any questions from the panel.
All right. Did you make your final point?
One last point is that this is a breach of contract. So the fact that Ms. Aldridge is representing to you, they fix this going forward, doesn't mean that any of the people in the past who were wronged have been compensated. And the fact that they have an attorney fee provision, there is no case holding that you treat a class differently because an attorney fee provision exists. She cited no authority for that.
Thank you
And
very
that's all
much.
I have, Your Honor.
Well
Thanks.
argued. You'll enjoy the rest of your day. Thank you.
Thank you, Your Honor.
And please hit leave. Thank you.